The Supreme Court has overruled its earlier decision in the Samiullah Baloch case. The court has also gone one step further in holding that until Parliament enacts a law making the provisions of Article 62(1)(f) executory, it will simply serve as a guideline for voters. Article 62 of the 1973 Constitution in its original form did not contain any of these qualifications. There was no Article 62(1)(f) in the original Constitution. The original Constitution simply stated that to qualify as a Member of Parliament, a person must be a citizen of Pakistan, not less than 25 years age in the case of the National Assembly, not less than 30 years of age in the case of the Senate, and such other qualifications as may be prescribed by Parliament. In the Zia era, through President Order No. 14 of 1985, various additions were made and various other qualifications were added in order to qualify as a Member of Parliament, including that a person must be of good character, must not violate Islamic injunctions, and must have adequate teachings of Islam. And Article 62(1)(f) was also added in Zia's era in its original form, and the original Article 62(1)(f) stated that a person must be sagacious, righteous, non-profligate, honest, and ameen. In the 18th Amendment, the elected representatives of the people not only retained Article 62(1)(f), but they also added to Article 62(1)(f). The amended Article 62(1)(f), as amended by the 18th Amendment, stated that a person must be sagacious, righteous, non-profligate, honest, and ameen, there being no declaration to the contrary by a court of law. The phrase "there being no declaration to the contrary by a court of law" was added by the elected representatives of the people in the 18th Amendment. Article 62(1)(f) cannot just be disregarded and discarded as being a dictator's creation. It was added to, endorsed in the 18th Amendment by the elected representatives of the people, and the courts must make sense of this constitutional provision. In the Samiullah Baloch case, the Supreme Court held that once a court had finally declared that a person was not honest and ameen, this declaration would have permanent effect. And such harsh and moralistic declarations of dishonesty should not result in a lifelong condemnation, and it does inevitably involve a subjective exercise. But Article 62(1)(f) does exist in our constitutional framework, and it is for the courts to make sense of this constitutional provision. Justice Yahya Afridi, the sole dissenting judge, attempts to make sense of this constitutional provision by saying that the declaration of disqualification will only remain in force until the court decision is in the field, and so if the court decision is not in the field, the declaration would not be permanent. And so Justice Afridi's decision also gets around the permanent effect of the disqualification, but this will become more clearer when his detailed reasons are out. And the majority judgment essentially makes Article 62(1)(f) redundant, and redundancy cannot be attached to a constitutional provision. It is also problematic from the aspect of the finality of Supreme Court decisions. It does not set a good precedent if every few years the Supreme Court changes its mind about what the law is, and it erodes the certainty which ought to be attached to decisions of the highest court of the land. And essentially it is the Supreme Court saying that it is neither infallible and nor is it final. As far as elections go, this decision does pave the way for those disqualified under Article 62(1)(f), including Nawaz Sharif, to now contest elections.